Good evening, ladies and gentlemen. My name is Anselmo D'Elia. I'm the chairman of Clinton Planning and Zoning Commission. I call this regular meeting to order. It is 7:32, and we have a quorum. Will the clerk please call the roll?
Anselmo D'Elia.
Here.
Alan Kravitz.
Here.
Michael Rossi.
Here.
Edward Alvarino.
Here.
Pamela Fritz. Here. Christine Goupil. Here. Michael Knudsen.
Here.
John Main.
Here.
James Staunton.
Here.
Maurice Kirk-Carr. Timothy Guerra.
Here.
Mark Rapuano.
Here. Okay, the first item is chairman's comments. I do not often make comments. I will make some brief ones. As I was saying, I don't often make comments, but I want to make some brief comments tonight. I want to recognize two individuals without whom we could not function, literally could not function. That's Julie Pond and Eric Knapp. They do a tremendous amount of work. They do it very professionally. They're very efficient when asked on a task, on a mission. They get the information back to us very rapidly. All of those seated on the commission know full well what I speak of. So I just wanted to give a heads up to those two individuals in particular. We also have fine staff otherwise, but these two are day in, day out, invaluable members of this town and this community. Item number 7, special exception 14-043, 140 Norwood Drive, Global Companies LLC, wholesale propane distribution facility. This is a matter that was continued to a public hearing, a final public hearing which was closed on 8/4/2014, and it is eligible for a decision. I would ask Mr. Alvarino.
Can't hear back here.
I just outlined what this matter is. It's the one you're interested in.
Yes, but we can't hear, sir.
Well, you know, I can only speak so loudly, and it depends on the volume in front of me as to whether you'll be able to hear it or not. I'll do my best. I don't have a microphone tonight. And I need to proceed at this point, Mr. Alvarino?
I'd like to recuse myself from voting, sir.
You're going to leave the room?
Whatever you want.
It's the process, that's all.
Yes, sir.
Thank you.
You're welcome.
Okay, some ground rules. I'm pretty good at those. Those of you who have been here before are familiar with my methodology. While this is a regular meeting and the public is certainly welcome to attend, there will be no public participation. So no shout outs, no applause, no comments, no questions. This is going to be a deliberation of this commission. This is what we've been elected to do, and we're going to do it to the best of our abilities. The comments that will come from within the commission may be audible, and they may not be. I can't speak for everybody. I'm going to shout out like I'm doing right at the moment, and hopefully you can all hear. I'm going to ask you to please refrain from comments from any exhibit of spontaneity, let's call it that, as best as you can. I know we're all human. We're going to take our time about this. I want to let you know that I have asked our staff, and upon review of council, we have actually prepared two separate motions. One to deny and one to accept. Approval is the other way, with conditions. So that's what's going to happen tonight. We're going to discuss one, both, don't know yet. We have not discussed it among ourselves, so we're all new to this, just as you are. We don't know exactly what's going to happen, but I do know that we're going to have some discussion. And I would ask our council to give us, members of the commission, some brief remarks about how we ought to proceed, given the fact that we have two motions. My sense is, and I'm prepared to make a motion relinquishing the gavel to the co-chair in order to make the motion. But first, I think you ought to address us with some legal comments.
Yeah, I guess the principal legal comment is that whatever motion it is that you decide to make, deliberate on, and vote on, I would ask that you attempt to identify the items in the record that were presented at the public hearing that are relevant and supportive of the motion that you decide to make, that you stick only to those items that are in the public record from the public hearing, and that you stick entirely to the wording of what was presented to you as well as your own zoning regulations when you decide whether or not to vote in favor of whatever motion is made. I think in this situation, making sure that you've covered as many of the issues that have been raised that may or may not satisfy your regulations would be a vastly superior way to proceed than to just make a motion, to either approve or deny without any discussion, deliberation, commentary, or findings. That's essentially what I would advise you, regardless of which of the motions you choose to make.
Okay, thank you for those comments. I'm sure they're all going to be heeded by all the commissioners. Julie, would you please tell us who's eligible to vote in our issue?
Alan, did you listen to the recording of the June 2nd public hearing? Alan?
Yes. Yes, I absolutely did.
Michael Rossi?
Yes.
Michael Nixon?
I did.
James, did you listen to the one from last Monday night?
I did not listen to the recording, but I did review the minutes.
I'm going to ask council whether that is sufficient on the law.
Probably not. And the minutes are not detailed as to what the evidence was that was presented.
All right, so I would say you're ineligible to, he can participate in the discussion or not even that?
If he's not seated, he shouldn't participate in the presentation.
He's seated.
Should I recuse myself?
No need to recuse yourself. You did not talk during the discussion.
Yeah. Yeah, if he's seated but not eligible to vote, it's kind of a disconnect.
Well, if there's a discussion, whether he'd be able to participate. Since he can't vote, then we're saying he shouldn't participate in discussions.
Yeah, I mean, the only decisions that the courts have issued come down that way. They treat basically unseated members as if they were alternate jurors who otherwise would be sent home and not participate. I think, probably in the grand scheme of things, based on how commissions work, that might be a little harsh, but if we're erring on the side of caution, I would say that you shouldn't participate.
Okay. I am going to seat Tim Guerra. I believe it's his turn too. And he has attended all three public hearings, so Tim, you're seated, and it's 7:56. For Eddie Alvarez. Okay. All right. Having said that, I relinquish the gavel temporarily, and I move to deny the application SC 14-043 submitted by Global Companies for a special exception to construct a propane storage facility at 140 Knollwood Drive, Clinton, Connecticut. And as a preamble, I want to state that the Clinton Planning and Zoning Commission received an application for special exception. This is lengthy, so you're going to have to bear with me. for special exception submitted by the applicant Global Companies LLC to construct a wholesale propane gas facility on property located at 140 Norwood Drive in the I-1 zoning district. The property is presently owned by Stanley Black & Decker and is the site of the former Bostic Staple Factory. The application was received by the Commission at its May 12, 2014 meeting and was set down for a public hearing. The public hearing opened on June 2, 2014 and was continued to July 7, 2014 and further to August 4, 2014. At the June 2, 2014 public hearing, a notice of intervention was filed by the Hammonasset Environmental Trust and Victor Caprio, in which claims were made that the conduct proposed in this application is reasonably likely to have the effect of unreasonably polluting, impairing, or destroying the public trust in the air, water, and other natural resources of the state. Also at the public hearings, the applicant presented materials and testimony, and members of the public, including the interveners, were permitted to present evidence orally and in writing related to the merits of the application. The Commission retained an independent engineer, Richard Lavingood, to review the application for relevant code compliance. The Commission also retained its own traffic engineer, James Bubaris, to review the traffic study submitted by the applicant. Now I'm going to read the material submitted into the record. While the following is not a complete list of all materials submitted into the record, the Commission specifically notes the following items as received and reviewed. Application for special exception dated March 27, 2014, submitted by Global Companies LLC as applicant, Stanley Black & Decker, owner for property located at 140 Norwood Drive, Zone I-1, Assessors Map 22, Block 10, Lot 17. Statement of use pursuant to Section 4.21 submitted by applicant. Certificate of zoning compliance issued by Julia Putnam, Substitute Zoning Enforcement Officer, dated March 28, 2014. List of procedures pursuant to Section 10.51.3 submitted by applicant. Representative picture submitted by applicant. Erosion control plans for the proposed facility prepared by Terracon dated April 11, 2014. Photometric plan, LPG rail unloading, Clinton, Connecticut, prepared by SFC Engineering Partnership, Inc. for Alliance Energy, dated March 24, 2014. Site plan of proposed fuel unloading facility, 140 Norwood Drive, Clinton, Connecticut, prepared by HDR and dated March 31, 14. Plot plan, proposed fuel unloading facility, 140 Norwood Drive, Clinton, Connecticut, prepared by HDR, dated March 31, 2014. Property survey of Norwood Drive, Clinton, Connecticut, prepared for Stanley Black & Decker, Inc. by Gessick and Associates PC, dated October 2, 2013. Overview property survey of 140 Norwood Drive, Clinton, Connecticut, prepared for Stanley Black & Decker, Inc. by Gessick and Associates PC, dated October 2, 2013. Flood hazard map, proposed fuel unloading facility, 140 Norwood Drive, Clinton, Connecticut, prepared by HDR, dated 3/26/2014. Review memorandum from John Gaskowski, AICP, consulting planner to the Planning and Zoning Commission, dated May 26, 2014. Review memorandum from Wade Thomas, PE, dated May 29, 2014. Property setbacks survey prepared by HDR, together with correspondence from Diane Whitney, Esquire, dated May 29, 2014. Report prepared by Fussin O'Neill, Robert Lewandowski, CSP, CIH, CHMM, Vice President, regarding the plume dispersion modeling, together with 2 attachments. Off-site consequence analysis, verified petition to intervene submitted by Hammonasset Environmental Trust and Victor Caprio on the Global Companies LLC application for special exception at 140 Norwood Drive, intervention dated June 2, 2014. Brief in opposition submitted by Keith Ainsworth Esquire on behalf of Hammonasset Environmental Trust and Victor Caprio in regards to Global Companies LLC application for special exception on 140 Walnut Drive. Brief dated June 2, 2014 with exhibits A through double J. Review memorandum from John Wiskowski, AICP, consulting planner, dated June 27, 2014. Response by Global Companies LLC to brief in opposition from the Hammonasset Environmental Trust, dated July 2, 2014, prepared by Diane Whitney Esquire. 11-page submission submitted by Ron Bodenson as a member of the Hammonasset Environmental Trust. Supplement brief in opposition submitted by Keith Ainsworth Esquire on behalf of Hammonasset Environmental Trust, dated July 7, 2014. Response to supplemental brief in opposition submitted by Diane Whitney Esquire on behalf of applicant, dated July 3, 2014. Correspondence on federal and state preemption submitted by Kenneth Slater Jr. Esquire, Commission Counsel, dated July 3, 2014. Memorandum submitted by Diane Whitney Esquire on behalf of the applicant, dated July 3, 2014, including attached photographs. Email correspondence from Keith Ainsworth Esquire regarding tank explosions, dated July 7, 2014, with attached photographs and web links. Review prepared by Richard Lavingood, P.E., dated July 7, 2014, analyzing canyon modeling submitted by Fuss and O'Neill. Traffic impact study of proposed propane distribution facility, Clinton, Connecticut, prepared by Vanessa and Associates, Inc., dated July 2014. Traffic analysis report prepared by James Barris, P.E., peer-reviewed propane distribution facility, Norwood Drive, Clinton, Connecticut, dated July 28, 2014. Clinton Planner Conservation and Development 2005, effective October 2007. Summary of preemption issues prepared by Diane Whitney Esquire on behalf of applicant, dated July 30, 2014. Memorandum from Diane Whitney Esquire on behalf of applicant regarding SC 14-043. The Clinton Planning and Zoning Commission, dated July 31, 2014. Ron Bodenson, response to Global's opposition to complying with fencing regulations with attachments. Memorandum from Clinton Economic Development Commission to Clinton Planning and Zoning Commission regarding Global Partners LLC propane storage facility proposal, dated July 31, 2014. Excerpted Form 10K submitted to Securities and Exchange Commission from Global Partners LLC for fiscal year ending December 31, 2012. Impact analysis of proposed Clinton propane terminal prepared by Heather Clinton. Reply to Global Company late file submissions prepared by Keith Ainsworth Esquire on behalf of Hammonasset Environmental Trust, dated July 31, 2014. Correspondence from Diane Whitney Esquire on behalf of applicant regarding independent research, dated August 4, 2014. Analysis of Global Partners LP memorandum dated July 31, 2014, prepared by Heather Clinton. Petitions and correspondence of individuals opposed to the application of various dates. Okay. Findings of fact. Based on the evidence submitted into the record, the Commission makes the following findings. The existing site is a brownfield containing contamination left over from the Boston Staple Factory use. The new facility, as proposed, would involve the cleanup of a relatively small portion of the site, with the remainder less likely to be developed given its existing conditions. The proposal is to utilize slightly less than 5 acres of the 38-acre parcel for 12 propane storage tanks. Each tank would hold 45,000 gallons of liquefied propane for a total of 540,000 gallons. The propane would be brought onto the site through a rail spur from the Metro North line. The cars would arrive 8 at a time, and there would be no more than 16 rail cars on the site at any given time. As shown on the plans submitted, the application appears to meet all requirements of the I-1 zoning district for bulk. Based on the testimony and photographs presented, the application is not exempt from the requirements of the coastal management regulations because the proposed activity can be visible from the water. No coastal area management permit has been sought. While the evidence indicates that the proposal meets all requirements of the 1995 National Fire Protection Association NFPA 58 Liquefied Petroleum Gas Code, which is presently in effect in Connecticut, as well as meeting the updated code, there remain unaddressed issues regarding public safety. Neither the commission, excuse me, gotta clear my throat, this is one thing. Neither the commission's own expert nor the expert retained by the applicant were able to satisfactorily explain what it would take, what force it would take to rupture a tank or multiple tanks. Neither the commission's own expert nor the expert retained by the applicant were able to explain what would occur from a safety hazard standpoint if a tank did rupture. The commission's expert's statement that he was willing to sleep under a tank does not adequately apprise the commission, please, of what the degree or what level of risk may be involved, and he was unable to describe with any precision the forces needed to puncture a tank despite repeated requests. Further, on direct question from the commission, the applicant's safety expert conceded that an armor-piercing bullet would create a hole in the tank and said he was not sure if this would cause an explosion. The commission finds that this is a very clear safety risk for which there is no effective remedy. The fire marshal and fire chief of the town of Clinton have both reviewed the plans and found them to be satisfactory. The evidence submitted indicates that the firefighters of the town of Clinton all receive NFPA 472, which is a training protocol specifically geared towards fighting fires involving hazardous materials as part of their Fireman 1 training. The firefighters have also received specific training on how to fight propane fires. The interveners have indicated that a levee would cause high-intensity heat to radiate out in an area at least 1/2 mile in radius. The evidence is supportive of their claims that the tidal marshes would be damaged by the presence, and I would say, in the event of a levee, the presence of the facility, and in the event of a levee. The commission finds that the allegations of unreasonable pollution are supported by the weight of the evidence. The commission further finds that the applicant has failed to offer any reasonable modifications which would make it less likely to have the effect of unreasonably polluting, impairing, or destroying the public trust in the air, water, and other natural resources of the state. Pursuant to section 1.4 of the regulations, the commission finds that the approval of this application would not promote the health, safety, and general welfare of the community, nor would it conserve the value of property or encourage the most appropriate use of land throughout the town. The application as presented would not secure safety from fire. It would not provide for public health, comfort, or general welfare in living and working conditions. Based on the evidence of preemption for fuel delivery, the commission is unable to find that the approval of this application would regulate or restrict the time of operation of trades and industries. Based on the evidence submitted from other business owners in town, as well as the Economic Development Commission, this commission finds that the approval of this application would not promote the economic and operational viability of the business in town, nor would it maintain the community character. Pursuant to section 9.2.1, this is all Clinton regulations, by the way. The location, type, character, and size of the use of any building or other structure in connection therewith is not in harmony with and conforms to the appropriate and orderly development and use of adjacent property. There are residential uses sufficiently close to the site that the peace of mind and quality of life of the occupants will be negatively affected by this proposal. I should say would be negatively affected by this proposal. Personal statements of the property owners as to values, together with the submissions by various real estate agents regarding property values, were not specifically contradicted by the applicant. Pursuant to section 9.2.2 and section 10.52.2b, the Commission has continuing concerns that in the event of a major fire, substantial evacuations would be needed and public safety would be in danger for a potentially extended period. Additionally, given the testimony that propane trucks leaving the site would need to turn into oncoming traffic on Route 1, the Commission does not accept that all actions needed to protect public safety have been undertaken. Pursuant to section 9.2.3, the Commission finds that the intersection of Knollwood and Route 1 does not adequately provide space for fuel trucks to turn into and out of the side street. Testimony was given by applicant's own traffic expert consultant that even at present, trucks frequently turn into the Ocean State Job Lot parking lot to be able to turn around and cross directly onto Knollwood Drive. The July 28, 2014 traffic report prepared by James Barbaras, PE, states specifically, and I quote, "We find that it would be highly undesirable to have a large tanker trailers to do so where their turning path would encroach on traffic traveling in the opposite direction into Knollwood Drive or eastbound on the Boston Post Road." End of quotes. The applicant has failed to address these concerns. There was uncontroverted testimony that Knollwood Drive narrows during the winter time, the period of greatest use by the fuel trucks, making traffic conditions more hazardous. The Commission heard that there may be a solution involving acquiring property from the estate of Stephen Hutt, but the Commission is unwilling to permit an operation of this sort based on the unknown possibility of a future agreement to arrange better access for truck at this crucial intersection, for which it has no evidence to conclude that this is likely to occur. Pursuant to section 9.2.4, the lot on which the use is proposed to be established does not contain sufficient area or adequate dimensions to permit construction and use of the buildings and structures in such a manner that it will not be detrimental to the neighborhood or adjacent property. In the event of an explosion, the buffering provided has not been demonstrated to be wide enough to provide a margin of safety to local residents. Pursuant to section 9.2.5, the proposal contains landscaping which would not adequately screen the neighborhood in the event of an accident. Pursuant to section 9.2.6, the plan as submitted is not consistent with the town's plan of conservation and development in that it does not preserve the character of Clinton as a small New England coastal town by protecting and enhancing the aesthetic and historic qualities of the town. Pursuant to section 9.2.7, the plan as submitted does not envision any street improvements which might be required to allow Knollwood Road to be used safely after the installation of the use of this type. Pursuant to sections 9.2.8, I should say section 9.2.8, the applicant has failed to provide evidence of the architecture of the proposed structures at the facility, leaving the Commission unable to determine its consistency with the neighborhood. The applicant has failed to demonstrate that the site will be safely secured during periods when it is not in operation. The use of security cameras monitored from an off-site location as the primary method of protecting the site is inadequate given the attractive nuisance nature of the facility and its location in an area which cannot easily be observed by local police. The need for remote individuals to contact the emergency personnel in Clinton, who would then need to respond without any on-site technicians, or experts will leave these personnel vulnerable to a hazardous situation. The individuals viewing the security cameras cannot easily relate any change in the situation to a responder on the ground, leading to potential delays in providing crucial safety information to first responders. The Commission cannot conclude that the requirement of a 14-foot tall opaque fence as required by the zoning regulations is preempted by state or federal regulation. At best, the applicant has offered evidence that this sort of fence would not be preferable or might be less safe, but there has been no offer of specific conflict with existing state or federal regulation and thus no preemption. The chairman of the commission asked counsel for the applicant directly for a direct prohibition and preemption, and counsel conceded that she could not provide such a citation. As a result, the commission, being unable to waive the requirements of its regulations, cannot grant a permit for a chain link fence of any height. The applicant would need to obtain a variance of this requirement or seek to amend the regulations to remove this requirement. There's language to decision, but we're not at that point yet. So, is there a second?
Second.
I'll take the gavel back. Thank you. Discussion. And we're going to have a lot of discussion.
First, Mr. Chairman, I just wanted to know, board reviews on my status.
You are not seated.
That's it.
So you are not covered.
Thank you. Ed?
I'd like to say something.
Yes, sir?
Just for my own satisfaction, I decided to take a site inspection. I drove to Bostitch property, drove in the property, and drove out of the property. There's a few things I'd like the commission to know about my inspections.
Is this new
Yes,
evidence?
Tim?
But
I would have counsel
Yeah,
caution.
if this is
this has to
information,
do with testimony that was given.
No, this is
It's
new
new
testimony.
evidence. It's a new testimony that you provided. We can't hear that.
That's right.
you're going to respond and react to the
Yeah,
proposed
good.
findings that the chairman has made and go back to testimony that has already occurred.
You can't give any new information because the public hearing was closed on August 4th. So you can't hear. And I want to just poll the commission that anything we've heard so far is not going to affect the member's decision, correct?
Correct.
Okay. Tim, you may.
I'll wait to
direct.
respond
You
later.
want to readdress?
Okay. Ms. Fritz.
Yeah, I'd like to, and what I'm going to comment on is specifically in the record that was given at the hearings. One of the issues that I had consistently asked the applicant about had to do with the property values. The property values would be affected. And the document that we received from them, the lengthy 71-page document, pretty much outlined, utilized the Albany facility as the example of property values. And I inspected that document very carefully. And the houses that were in that particular area were built, they were row houses, and they were built many, many, many years ago. So the value of those properties was like 30,000, 50,000, very low value. So I just wanted to say that that document did not, in my opinion, support a comparison with Knollwood Drive and the residences in that particular area. And I think the only other thing that I'd like to comment on, which I think was well done in how this was presented, was we heard many, many times about how it's not likely that something could happen, or that there would be a disaster of some sort that would be likely. And the only thing I can say is that, from my own perspective, you know, not too many years ago, if somebody told me they'd fly 2 airplanes and collapse 2 big towers, I would say that would be very unlikely to ever happen. So I think that the likelihood is much different in this day and age than it was a few years ago.
I'd just like to speak in support of what Pam said. And I think there's a stronger case. I think that the evidence presented in that particular statement, it doesn't support the conclusions. It's not that the selection of the topic of the site was inappropriate for one reason or another, but the evidence presented itself doesn't support the conclusion that it has a negative effect. It doesn't have a propane facility would not have a negative effect on property value.
I just want to remind you, and I would ask that we add the language if we were to adopt and adapt the motion that you heard me around and breadth that the applicant's representative stated that it would be too difficult to isolate factors which impact property values to draw a specific conclusion. Page 5, where we say we were not, where I say that the property values were not specifically regarding the issue of decreasing the property value that would not be specifically contradicted by the applicant. I would add that the applicant itself said that they couldn't give us any conclusive information regarding property values because there were too many factors. Well, from my perspective, anyway, if you can't tell us for sure, then if you're going to make a decision, you have to base it on the worst case scenario.
Well, and I just like to add to my comment on that issue, in that, there were multiple people who were realtors for a very long time who came forward. And I really did appreciate all of the people that came forward, because even if there was some maybe repetition in some of the content, everybody had a little different perspective. And I think that was very valuable to have these hearings. But anyway, the realtors who came forward all had specific things to say about property values that did address the issue.
As I recall, most of those realtors, if not all, were local realtors.
They were all, yes, they were all local.
Any more comments?
I have a comment with respect to safety considerations. We asked a question about derailment. The applicant's response to that question really didn't take into account the physical configuration of their own site. They responded that it was more than 350 feet from the rail line where the derailment, the main railroad line, where the derailment might occur, to the tanks. But between the rail line and the tanks sit approximately 16 tank cars loaded with propane. And as many as 60. And the loading facility for the trucks. Those are considerably more proximate to the potential location of a derailment than the tanks. It just didn't respond to our safety concerns.
My comments only are this, that the existing 50,000-gallon tank used for manufacturing purposes, 30,000-gallon. In either case, to increase that size of fuel base for distribution hub rather than manufacturing fundamentally changes the site itself from manufacturing to a distribution hub, which significantly supports this denial. In essence, changes the nature of that site. That's my opinion.
I have one other thing that I heard something from what you just read, and that has to do with, I believe that the traffic authority in the town of Clinton is the police station, isn't it?
is.
Okay, so therefore, I remember at one of the hearings that the applicant indicated they had met with the first selectman and this property owner regarding that turning issue, whatever. And I just meant that anything that had to do with traffic has to go before the police commission. That's the true traffic authority.
Well, we had a traffic study.
Right.
They had theirs, and they too found the problem at that intersection. And ours, the individual we engaged, came to the same conclusion. And in fact, if I recall correctly, even though he's not seated, or he's seated, but he's not going to be voting, Mr. Staunton raised the issue of that traffic turn on Route 1 from Norwood Drive. And that alerted me to the infinite possibilities of bad things happening. So I paid very close attention to both traffic studies, the applicants, and when we engaged. And sure enough, as the motion mentions, you know, the possibility of being able to do something when you're dealing with a use of this nature is not sufficient, in my view, to grant even with a condition. Anybody else? We're going to have to modify the motion if we're going to introduce other elements to it. We've had a couple of discussions. I think Alan mentioned the train derailment possibility. What's that? Yeah. We're gonna take our time to figure it all out. We're done. If this motion is the one that is voted for, then we will make the modifications. Okay? Anybody else? Surely you have other comments. It's important to thoroughly discuss the motion you voted. So you've had it, it was distributed this morning. I hope you all read it.
Additional copies, if anyone needs additional copies.
You know, if you want to take some time to go through it, you know, I made some additional notes on it. As you heard counsel point out, you know, it doesn't have to be verbatim as you heard it. In fact, there's, you know, particular provisions of it should be discussed and made ours. We're going to vote on it. We have a motion, a second, we're having a discussion. At some point when the discussion is concluded, we're going to take a vote on that motion. And depending on what happens, we may not reach the other motion. If I'm getting the sense here, that's probably what's going to happen. But I would like to have language reflecting our deliberations right now to be introduced into the motion that I read.
I have nothing to add to this motion.
You like it as it is?
I cannot support this motion.
You cannot support this
I
motion?
cannot support this motion. And that's all I'm going to say.
Any other comments?
I'd like to comment that we raised the numerous hurricanes that we've had and the fact that it is an area that is going to be potentially inundated with water should that happen. And during that time, what is going to happen is we're going to lose power. We all know that many of the areas in Clinton lost power for a significant number of days. The site is operated, the gates are operated by electricity. Should that go down, potentially the gates won't open. If first responders do need to get into the site, that's going to be an issue. Also, if there's an issue on the site, and the responders are going to have to address numerous problems throughout town, you know, how do you make a decision which one to go to first if you don't know what exactly is problematic on the site, because you can't view it because there's viewing only through an off-site location. So how do you communicate that type of level of need when you don't really know what's going on as well? So there's multiple problems just in terms of the security of the site.
And I would add to that, because it's surrounded by water, there's one way of egress in and out, so it's very difficult to get an angle on the property from any other vantage point than one single way. You have fire and incident, and it's coming from that direction.
No one into that property.
No safe way for our fire crew to get there and install.
Any other comments? I haven't been taking notes, but I heard three things that I would like to incorporate into it, at least. The comments Mike Woodson just made is a very valid comment. Ingress, egress being only one, that is very problematic from a safety standpoint. And we should probably incorporate it into the motion I read. I think that is a traffic component as well. It should be, would you agree, Mike, is that, where would you think we want to introduce that aspect of it?
One I don't have printed out.
Mike, please speak up.
Oh, I'm sorry.
I need to be able to.
Oh, if everyone else is in agreement, maybe under section 9.2.2, under the regarding of the evacuation.
Yes, that's probably the most appropriate portion.
That there's a lack of a secondary egress, and with the water surrounding the property, there's a lack of viewing from any other vantage point.
And lack of ingress, would you say, for the fire trucks
Or
to reach, or an explosive, or a
Yes.
fire condition?
Absolutely.
That roof is damaged.
Now, we to amend the motion with the consent of the mover, and how should we do it procedurally?
I think that would be, we would do it just as an amendment.
As an amendment to the motion? Will we go on down with other amendments, if we have other amendments, continue?
Yeah,
forward that
take
way?
them as they come up. By the end, what is voting.
We should vote on the amendment. May I have a motion to make that amendment as outlined by Mr. Newton?
Mike, we can actually make that as the,
He can make the
he
motion.
can make the motion to amend the
I
motion.
make a motion to amend the motion to deny application.
If you make the motion, you move to amend the motion that's on the floor.
I make the motion to amend the motion that's on the floor.
Right.
That's
And I
it.
Is there a second?
Thank you.
Is there a second?
Yes.
Any further discussion on that proposed amendment to the amendment, to the motion that's on the floor? All in favor? Opposed? Abstained? Okay. The motion on the floor is amended with the language introduced by Mr. Newton. Anybody else want to submit?
I just want to ask you that because the point I was making had to do not only, I have here under 9.2.1, the personal statements of the property that's been submission by various real estate agents regarding was not contradicted by the applicant. But the point that I was making, and I don't know if it's in here, maybe I missed it when you were saying it, is that the applicant did not sufficiently provide the answer to the property value evaluation, or all, whatever. In other words, what they provided was the comparison of the row houses in Albany, which is no way a comparison of the residential area in which they are proposing to.
Well, it's already appraisal, we weren't providing.
We weren't, I don't know how we would word that, but I think that would be appropriate, because it isn't just that they didn't, whether they didn't contradict anything.
The language that I would suggest, and to address the point you're making, is that the applicant's representative stated that it would be too difficult to isolate factors which impact property values and therefore fail to provide a full assessment of whether or not it would impact property values. Therefore, we have to conclude that it would.
Off the language, speaking on your behalf just for a second, I think what she's also saying is she found the evidence provided by the applicants of the Albany facility not comparable and not persuasive because it was not comparable to the situation.
That is what I am saying. That's what I was proposing to provide, which is not comparable.
So why don't we add that sentence? And we can move to add that sentence to motion on it. EC's written it down.
That the information provided by the applicant regarding the Albany facility was not comparable to the situation here because of the quality of housing at the Albany facility versus the quality of housing here. Is that what you're saying?
That's what I'm saying. So
You move.
So moved, is there a second?
all right.
I'll second.
I move to amend, all right.
And I'll second.
Motion second.
Any further discussion on that amendment? All in favor, say aye. Aye. Opposed? Abstained. Okay, it's amended further.
But also add, and with respect to the back of the question, also in the same paragraph, that the Assistant General Counsel at the second public hearing made two unsubstantiated statements regarding successful development proximate to major storage facilities. He made those statements offering no specific evidence as to how those projects were successfully completed. He made two explicit statements regarding one near Suffolk Downs in Boston, and the second project he didn't locate with respect to, he said it was a luxury housing project. And that he said that they were no way impacted, and yet he offered no evidence of that, no substantial evidence of that.
So you're proposing that amendment
As
to the motion on
a
the floor?
further evidence, it's an evidentiary statement.
So that was part of the original testimony anyway, was that just?
Well, you mean as a finding of fact? Is that what you're saying?
It's a finding of fact.
So you want to add, it's a motion to add an additional finding of fact, as I understand your motion, stating, we'll say it again, so the record can properly.
Yeah, that the general counsel for the applicant, or assistant general counsel for the applicant, made two unsubstantiated assertions regarding two projects where the development was successful in proximity to a substantial, he didn't even locate one of the storage. He didn't actually locate either of the storage facilities. So he was trying to justify their claims that by saying that it would be effectively neutral. But he offered no evidence.
I'm just trying to put words in your mouth here. Let me see if I can summarize this in a way that may.
Okay, go ahead.
Evidence was provided by Global, or a suggestion was made by Global that there were other successful developments around propane facilities, but these statements were not supported by substantial evidence. Okay? Is that
That's fine.
So that's the motion.
That's the motion. Accept that then.
As part of the findings.
as part of the plan?
Any further discussion on that motion to amend along the lines you just heard? All in favor, say aye.
Aye.
Opposed? Abstaining?
Abstaining.
Just hand him your gavel and then do the motion.
You got the gavel, Alan.
Thank you.
I make a motion to amend the motion on the floor to add the language on page 5 of the draft, paragraph 4, 9.2.1, after the language were not specifically contradicted by the applicant, I would like to add, the applicant's representative stated that it would be too difficult to isolate factors which impact property values. And that is insufficient to maintain the argument that the property values would not be affected. So that's my motion. Is there a second?
Second.
You're running the show today.
Is there a second? Seconded by Van Fritz. Any discussion? Hearing none. The question, all those in favor, cry out by saying aye.
Aye.
Opposed? Abstentions?
Abstaining.
Let the record show that one abstention. Anything else?
Okay. Anything further? Any more discussion? We're all satisfied with the motion I made with the amendments introduced to that motion? If so, I guess we're going to vote on it, so.
Is there any further discussion on the motion to deny as amended? Hearing none, the question will be called. All those in favor, cry out by saying no, signify by saying aye.
Aye.
I'm just,
Show of hands.
Show of hands.
I'm just gonna read them off. Tim, Mike, Alan, Anselmo, Christine, and John.
All those opposed,
Right.
abstaining,
And not voting is
James Stockton.
Mark, because he's not standing, James is ineligible. That's everybody, right? I got everybody's name? Okay, I just wanted to make sure I got everybody.
All right, the application is denied. Thank you.
Brought to you by Nosy News Agency of Clinton.